So let me first thank the Asian Development Bank Institute for the kind invitation to speak today in front of this distinguished audience. I'm particularly grateful for Professor Sita Ram and Veronica Wee for the organization, the kind invitation. I'm also grateful for Professor Ramanathan for accepting to kindly moderate the questions and answers after I will talk for a little while. My name is Florian Grisel, as you already know. I'm an associate professor of Socio-Legal Studies at the University of Oxford. A large part of my past research has dealt with the development of international arbitration, a field that I've been able to practice as a lawyer in private law firms, but also at the World Bank, as Veronica mentioned. And today, what I'll be doing is to focus on arbitration in major industrial projects, and I'll be presenting what I call some practical insights, but also some empirical analysis based on both my experience as a researcher, but also as a practitioner of this type of arbitration in major industrial projects. So let me walk you through the kind of outline that I've set out for this keynote, but I'd like to emphasize before I start speaking and give you the outline that I will take questions and answer also during the keynote. So I will ask you a few questions because I'd like this keynote to be more of a dialogue than a lecture where I'm telling you what I know about the field. I think the benefit of this group is to basically engage together on this topic. So what I will start is to define a few key concepts, and I will do that with you. So I will ask you a few questions about these concepts, and I will kindly ask you to give me your insights based on what you know. And you may know a lot or you may not know so much, but it doesn't matter. The point is to try to understand together a few basic concepts. So the first part will be about definitions, and then I will describe what I call the use and abuse of international arbitration. I will then explore the post-colonial roots of international arbitration. This is what I called international arbitration, the unwanted child of major industrial projects in the Global South. And then finally, I will analyze other possibilities for the resolution of disputes arising from major industrial projects, namely what is called dispute boards and public courts. But let me start with a few definitions. We should first try to understand what we're talking about here and what arbitration is about. So I'm sure a lot of you may have an idea of what this is. You may even have defined it in the prior sessions, but let me state on a preliminary basis a very simple definition of arbitration. Arbitration is a mode of dispute resolution based on the consent of parties, and that's a very important aspect of arbitration. This consent is usually contained in an arbitration clause that can be found in a contract or a treaty. Disputing parties typically nominate 1 or 3 arbitrators. It can be up to 5, but this is very unusual. Usually it's 1 or 3. And these arbitrators are called to make a final enforceable decision in a judgment called an arbitral award. We might come back to this aspect later on. So this is, in very broad terms, what arbitration is. Now let's think together about what industrial projects are. So industrial projects is a very kind of blurry notion. It can capture many types of contractual relationships: oil and gas concessions, mining concessions, large construction projects, airports, plants, major infrastructure such as highways and roads, but also large commercial contracts for the sale of big equipment such as aircrafts or military equipment, which are often associated with major technology transfers. But beyond this apparent diversity, I would like us together to think about the key features of these major industrial projects. And I would like to know what you think are the key features of these major industrial projects. If you think of these major industrial projects, what kind of features do you think of? What are the kind of associations of ideas that you have? So I'll give you the floor, whoever wants to say what they think characterize major industrial projects, and then I will give you what I believe are the important features. But I'd first like to hear you. Anyone? If you think, for instance, of an oil concession, what is so characteristic of an oil concession? Don't hesitate.
Answer?
Yes, of course. I couldn't see any hands raised, but please feel free to answer directly. Yeah.
Okay, nice to meet you. Thank you for the introduction, the webinar. So for the when we talk about industrial project, the key features, like key characteristics, there are many, of course, characteristics and complexities. So one potential characteristic feature is there are many stakeholders involved in this kind of industrial project, and always there would be power imbalance between these stakeholders depending on their capability and also their interest and willingness, and also sometimes capacity of the different stakeholders involved in the project. So also the another key features of this kind of industrial project is they always have a huge, the social and social, economic, and cultural consequences of the big industrial project. Then it, have to say, triggers the condition, causes of the dispute or kind of, conflicting situation.
This is very good. I will come back. Thank you very much. I will come back on these aspects, particularly on the second one in a minute. But I would like to hear from the other members of the audience if they have any other ideas complementing what Selmeg Saikan just explained to us. Yes, Kishore. I think the mic is muted.
Yeah, can you hear me?
Yes.
Yeah, you see, so when we talk about the industrial projects, so the picture that comes to mind generally is that something very big.
Yeah.
It can be like some either construction of some major airports or hospitals or oil and gas pipelines. So that kind of picture. Also, what one thing that it has a lot of the partners, the stakeholders, and it is going to have a lot of impact on the general public. So in terms of the employment, and so these are very long-term projects, and they may have some adverse effects also, either on the local population or the again, if there is a change in government, it depends on the political system also of that country.
Absolutely. So that's exactly what I want to head towards, and I'm very satisfied with these answers. So let me focus on what I believe are the three key features that I can keep in mind and that I'd like to base the rest of the discussion on. And I think each of these elements have already been mentioned by each of you. So thank you for this. The first element, and that's what you just mentioned, is that these projects are implemented in the very long term. That's a key aspect of these major industrial projects. These are very long-term projects. So what do I mean by long-term projects? It means 5 years and plus. It can be 10 years, it can be 20 years. An oil concession, for instance, or a mining concession is a very long-term contract. I've seen myself a concession agreement for 30 years, and that's not something unusual. So why is that important, that this first key feature, the long-term aspect of these contracts? It is important because over the very long term, disagreements are more likely to arise. It's a little bit like a marriage, okay? You always end up disagreeing at some point because you spend so much time together. But the other aspect that is very important is that because these projects unfold over the very long term, these disagreements, it is particularly crucial to solve these disagreements quietly before they degenerate into full-fledged disputes. So I will ask you to remember one aspect, the first key feature, the long-term dimension of these projects. The second dimension, which is really important, and both of you have insisted on this, is the fact that they are big. These are big projects. And in fact, the title is Major Industrial Projects. What does it mean? It means that these projects involve high financial, but also political and social stakes. So financial, I think it's pretty obvious to anyone here that when we're talking about major industrial projects, we're talking about a lot of money. And I think that's common sense. There is not much to say about it, but it also has very important social and political consequences on local populations and local governments. For instance, I mean, one example that goes to arbitration are water concession rights. And there were a few cases in South America about water concession agreements that led to disputes between public entities and foreign investors. And these cases were brought to ICSID, to the International Center for Settlement and Investment Disputes. It is fairly obvious that contracts over the provision of water to local populations has enormous social consequences. And these cases matter tremendously beyond the simple industrial aspect of these cases. So second key feature, high financial and political stakes. These are big projects. The third key feature that I'd like to talk about is the fact that these projects, that's a very important aspect, they often involve public entities. And public entities are likely to be involved in two main capacities. One is as contracting parties. For instance, a concession agreement will typically be signed between a company, usually from the north, but not always, and a government or a governmental entity, or the contracts for the construction of public facilities are another example where public entities are involved as contracting parties. But public entities can also be involved not as contracting parties, but as regulators. When, for instance, a major industrial project is affected by the regulatory decision of a government or a public entity. And I'll give you one example, very recent one from last year, where an ICSID tribunal, an arbitral tribunal, ordered Spain, the country, to pay a Japanese solar power producer over $23 million of damages, plus interest and costs, after finding that changes to the state's renewable energy regime frustrated the legitimate expectations of these Japanese solar power producer. So three features: long-term projects, high financial and political stakes, and involvement of public entities in two main capacities. So I will ask you to keep these key features in mind so that we can later think critically of what the best dispute resolution system for these types of projects and disputes might be. But before we do that, let me turn to my second point about the use and abuse of international arbitration. And I will draw your attention to the slide in front of you and the two graphs in front of you, which are taken from my book with Alex Stone-Sweet on the evolution of international arbitration. So the graph on the left shows the number of cases submitted to the International Chamber of Commerce, or ICC, which is the main arbitral institution in the field of international commercial arbitration. So it's the number of cases, arbitration cases filed with the ICC between the early 1920s and 2015. So that's the graph on the left. On the right side, you see an equivalent graph for ICSID, the International Center for Settlement of Investment Disputes based at the World Bank, which is the main arbitral institution for investment disputes. And here again, you see the evolution of the number of cases filed between the early 1970s and 2015. So what you can see in both cases, in the case of the ICC and the case of ICSID, is pretty evident. You see a steep increase in the number of cases submitted to international arbitration in the 1960s, 1970s in the case of the ICC, and you can see the red arrow on the left, and in the 1990s in the case of ICSID. Now, I would like to hear from you again about what you think are the reasons for this success. Because there is a kind of dominant discourse, and you may have heard this discourse about the reasons why arbitration is so effective and why it has been attracting so many cases over the decades. So please tell me what you think are the reasons for this success story of arbitration. Kishore, yes. You might be muted, Kishore. I can't hear you.
Sorry. What do you see after the end of Cold War and disintegration of Soviet Union? So there was, you see, all over the world, this new kind of economic model. So Washington Consensus, whatever one may say. So a wave of privatization, liberalization, globalization. So there was this huge demand for investment in the erstwhile the closed economies, one can say. So they became transition economies. So Asia, Africa, Latin America, Eastern Europe. So that obviously created more and more stakeholders in the process of industrial development all over the world. So more and more investment, more projects, so greater involvement of states, and also more investment treaties, and therefore more disputes, and therefore a larger scope for the dispute resolution institutions to handle and decide these disputes.
Yes. Okay, that's part of the story, but that cannot explain all, right? Because you could imagine that other dispute resolution methods would have been adopted. But we'll come back to that Washington Consensus aspect. I do believe it's a key explanation, but I will develop this a little bit. We have two more hands that have been raised, and I will start with Krishna. Krishna, please.
Yes, am I audible?
Yes.
Yeah, so I would like to mention that it's a more time-effective mechanism, arbitration is. And it's also quite flexible when compared to litigation, because you don't have the same procedural rules and you don't need to follow the strict procedural aspects which are there in litigation and other forms of ADBI.
Very good. Okay, I'll come back to that. That's very important. So next is Shreyas. You raised your hand.
You have to unmute yourself.
Can you hear me now?
Yes.
Can you hear me? Okay. Yeah. I have 2 quick points. One is the New York Convention, which is just the most successful international convention signed in 1958 and does not have any parallel for cross-border enforcement of court decrees. The Singapore Convention has now come up, but it will take many years for it to catch up. Secondly, perhaps is the rise of China, which may not be talked about very much, but it was around this period of time to the 80s and 90s, or maybe 1978 onwards, that China really opened up. And so that created an irreversible trend in globalizing supply chains like never before. And I suspect, although the two have not been linked in traditional discourse, I suspect that's a strong reason. Thank you.
Very interesting, Shreyas. Yeah, that's something I will keep in mind for the future. But I will ask, I saw another hand, and I think this was it Shitra, I think, raised her hand. Yes, please, Shitra, you're next.
I'd agree with Shreyas on the New York Convention. A couple of other things, I think decolonization around this time, and that we sort of adopt standard form contract. I think it was inverted. Things may be a little different now, but it was the North that was investing, and we in the South were receiving investments. And if we were to get those investments, we had to agree to these terms. So it was a standard form that was imposed.
So Shitra, I think that's a key aspect, and I'll come back to this. This is very good. And I'll end with Meg, and then I will try to summarize these different strands of arguments. Meg.
Okay, my answer is quite straightforward. Of course, I agree with the others' answers about the international trends and key milestones, key events. So my answer is, in my understanding, arbitration is a kind of alternative approach to solve the dispute. It's quite different from the conventional, traditional dispute resolution. So therefore, maybe because of that different approach, and I think that might have an effectiveness comparing with the traditional one. So therefore, maybe becoming quite maybe get recognized widely.
Thank you very much, Meg. Okay, let me try to reflect on your answers. I'm actually quite fascinated by your answers because I can see you're all sophisticated actors who can read through the kind of usual discourse, but I also see traces of this discourse that that are left in your own answers. And so I'll give you the unsanitized kind of version of the discourse that is usually built around the success for international arbitration. And the discourse is the following: arbitration is cheaper, faster, and more neutral than other modes of dispute resolution. But as we know, and as I have a sense you already know, but I will say a few words about this discourse does not fully resist empirical scrutiny. So let's start with the price. I mean, arbitration is not cheap. It is very costly. And I can cite, for instance, the case of the Philippines, which reportedly paid in a case $65 million to its lawyers. So the Philippines, it's not the wealthiest country in the world. It had to pay $65 million to lawyers for an arbitration case. It is not cheap, it is very costly. Arbitration is not fast, it can be very slow. And again, I will go back to the Philippines and refer to a case which you may have heard of, which is called Fraport v. Philippines. Fraport is a German company specialized in the provision of services in airports. And Fraport filed an arbitration case against the Philippines in 2003 before ICSID. This case took 4 years until 2007 to be dismissed for lack of jurisdiction. 4 years to be dismissed for lack of jurisdiction. Then this award that dismissed the case for lack of jurisdiction was annulled 3 years later in 2010 by what is called an ICSID ad hoc committee. I can tell you what it is later on if you'd like. So because the first award was annulled, the German company, Fraport, filed a second case, which was virtually the same as the first one. And this case was filed in 2011. This second case was dismissed 3 years later for lack of jurisdiction in 2014. I will let you do the math. It took between 2003 and 2014, 11 years for a case to be dismissed for lack of jurisdiction. A case that cost $65 million to the taxpayer of the Philippines. So very, very slow. It almost compares to another famous case of international law, the Barcelona traction case, which took 12 years to be dismissed for lack of jurisdiction by the International Court of Justice. So only neutrality seems to stand for the success of international arbitration, but I would like to say a few words about this neutrality and with this idea that private tribunals are more neutral than public courts or other modes of alternative dispute resolution. And I will argue, and that's my third point, that international arbitration emerged not because of neutrality, not because of speediness, not because of cost, but it emerged precisely in the context of what we're talking about today, the large industrial projects in the wake of decolonization. And someone mentioned that earlier, and I think that's a key element to take into account. International arbitration is the unwanted child of large industrial projects in the global south. The emergence of international arbitration in the 60s and 70s, you saw the graph from the ICC, can be associated with the decolonization process and the emergence of a global south that promotes respect for sovereignty, non-aggression, and non-interference in internal affairs. In this context, former colonial powers very often impose the use of arbitration as a means of settling disputes in large industrial projects. The ultimate reason is that former colonial powers did not trust newly independent states and their local courts with the settlement of disputes, particularly when these disputes involved public entities. At the same time, these colonial powers could not possibly afford to impose the use of their own courts, which would have been an obvious slap in the face of newly gained sovereignty. And as a consequence, the second best option was the seemingly neutral dispute resolution body of international arbitration, which was praised for reasons that are altogether different from the real reasons, namely speediness, cost effectiveness, etc., etc. Now, I have tried to challenge very quickly the mainstream discourse, but where does it leave us concerning the settlement of disputes arising from major industrial projects? And that leads me to my last point. And here I would like you to think of the three key features of industrial projects that we have identified together, namely the length, long-term projects, the high political and financial stakes, and the frequent involvement of public entities in different capacities. And here I would like you to think of what Professor Uma Ramanathan and others have taught you already about the importance of problem solving, identification of key interests, and the need to resolve disputes through capacity and consensus building. We need to keep an open mind about which method is the best for the resolution of these major industrial projects. People jump automatically to the solution of international arbitration, but there are many more options, as you have already explored today. My belief is that each industrial project deserves its own system of dispute resolution, depending on the relationship at stake, the key interests and cultural expectations of the parties. That's a very important aspect, and we may talk about it again later. But of course, if we want to generalize, and based on my experience and my expertise in the field, I see two types of dispute settlement methods that could offer interesting alternatives to arbitration. These dispute settlement methods can be used separately, but they can also be combined. The first one of these dispute settlement methods is very informal, and you may have heard of it or not. It is called dispute boards. So dispute boards are panels of experts, and these experts are available throughout the implementation of these long-term projects, and they can be called upon to make recommendations. They make recommendations. They do not decide. They let the parties adopt their recommendations to solve technical or legal problems that can arise during these projects. You will tell me, oh yes, but you know, the parties are then free to refuse to adopt these recommendations. In practice, the parties very, very often adopt the recommendations of the dispute boards. They are very effective, and they contribute to what we call, and I'm sure you have explored this earlier in the other workshops, the deflation of disputes. They make sure that any kind of disagreement doesn't translate into a full-fledged war. I feel like these dispute boards could be particularly useful for major industrial projects, considering the long-term dimension of these projects and also the high political and financial stakes involved in these projects. We do not want disputes to arise from these projects. We want issues to be solved in a reasonable way throughout the implementation of these projects. The second one of the dispute settlement methods that I would like to talk about, besides the dispute boards, is less informal and more traditional. And it might seem surprising that I mentioned this, but I do believe that it is well adapted to certain features of major industrial projects. And this method is simply the judicial process provided by public courts. I believe that the public character of industrial projects, the involvement of public entities, and the high stakes involved in industrial cases make it particularly important from a rule of law perspective to involve public courts. It's all the more so as the focus on arbitration is a way for governments, and it has been proven, to justify underinvestment in their own public court system. Why would you invest in your own legal system when you can reassure foreign investors that they will have their day in court by including arbitration clauses in your commercial contracts and your investment treaties? In other words, arbitration has been creating a disincentive for states, and I'm talking particularly of the Global South, to invest in their own court system. It is time for these states to reinvest more heavily in their own courts and to let them develop the law in light of the public interest of these states. Now, I've given out some of my own views on arbitration and its limits in major industrial projects, but I would first like to thank you for listening so carefully and for participating with questions. And I have put my email address if you want to correspond by email. But in the meanwhile, I would love to hear your questions under the supervision and the moderation of Madame Uma. Thank you very much. I will stop sharing so that we can all see each other.
Thank you, Florian. It was such a great thing to listen to, the real impact of arbitration and what are the things that we have to look out for. One concern before we open up the questions for me was, you were talking about being attracted to arbitration because of neutrality. I was thinking about how does neutrality and confidentiality impact, especially when you promote the cause of public courts. And you also say when major industrial projects have been there because of which this was an unwanted child. Now, how do you relate to it, and how do you say that neutrality and confidentiality will be protected and at the same time will get satisfaction for the parties?
Let me make myself clear. I believe that part of the discourse advertises neutrality as a good thing and as a key feature of arbitration. I do not share that belief. I want that clear. But I will answer your question concerning confidentiality, and that's something that is another aspect of international arbitration that we could talk about. So confidentiality is very relative in the case of ICSID decisions, which are mostly advertised and publicized, but not always by legal means. So there is a kind of systemic defect in the sense that all decisions are not advertised. I know of ICSID decisions on which I've worked in the past that are not in the public domain. And I believe that these decisions are important for the citizens of the countries, for other scholars of international arbitration, etc., etc. So that's investment arbitration. Commercial arbitration is even worse. Commercial arbitration, even when a public entity is involved, even when the public interests are incredibly crucial in the case at hand, most arbitral awards do not become public. So the ICC has been trying to, for many years, to relax this confidentiality, but I'm not too confident that this will be followed by practical consequences. I believe this is a major problem. Again, I've also been confronted in the past with arbitral awards, and I was truly shocked that these arbitral awards would not be made public, simply because the issues at stake are absolutely crucial for the public interest, and the taxpayer is very often called to pay the bill. So that's something that I believe fully justify the complete transparency of arbitral awards, except for very, very narrow reasons. And I think certainly whenever a public entity is involved, transparency, should be a given. Yeah. So thank you for that question.
No, I just had this because today we have a lot of hybrid processes where you have ARB-Med and Med-Arb. And so again, this has the play of confidentiality and neutrality, and this does raise concerns. That's why I brought up that question. I think we leave it open to the audience now.
Absolutely. I can talk more about these hybrid processes if needed. I would be very happy to do so. But let's see. We have a question from Shreyas. Shreyas, please.
Thank you again, Professor, for your very strong views on arbitration. I have a more pragmatic question. Is it not correct to say that arbitration may not be liked, but like democracy, it's the least worst system we have? And for adversarial adjudication, it's highly imperfect, but for adversarial adjudication, there doesn't appear to be another option, number one. Number two, there appears to be hardwired into the investment treaty regime for the next couple of decades at least, a lot of investment treaties arbitration, which we are all likely to see. Even countries like India, which have terminated its BITs, still have sunset provisions for 15 years. We're not going to see less of it, we'll see more of it. And therefore, in this light, is it not correct to maybe accept that arbitration is here to stay for the foreseeable future, and instead to look at diversity, increasing reasoned awards, and increasing the quality of arbitral output?
Okay, that's a great question, Shreyas. And to the first part of your question, I'll give a pragmatic answer to a pragmatic question. I think I agree with you that there are only imperfect alternatives. And I agree that arbitration is one of these alternatives. However imperfect, it's one of them. I see major flaws with arbitration in certain settings. I have absolutely no problem with arbitration when the parties want a binding decision in a commercial setting. Today's topic are major industrial projects. This is a special breed. I've worked on many of these projects, and whenever I worked on one of these projects, the public component of this project is overwhelming. And I think that justifies a better system, one that is more transparent, one that is more likely to preserve some key aspects of the public interest, such as money and time. I think this is really important. The second question is a very important one. You are telling me, well, this is all very interesting, but arbitration is not going to disappear anytime soon. And I agree with you. I fully agree with you. I think for many reasons, one being the kind of path dependence in the system and the fact that many actors are involved in this system, I think it's unlikely to disappear for at least a few decades. I fully agree with you. This doesn't mean that we should not think about the future and try to prepare what is to come next, because I do believe that over time, something else is to come next. And it's not necessarily a big problem. Now, I would like to say one more word before taking more questions, because Shreyas, you mentioned something. I believe you're the one who did that. You mentioned the New York Convention. Are you the one who did that earlier?
Yeah.
Yes. So I think when you did that, you did in fact put your finger on what I believe is the major advantage of arbitration compared to other systems of dispute settlement. So I portrayed arbitration in a very negative light, and I did it on purpose to a certain extent. I think there is one extremely positive aspect to international arbitration, and that's the mode of enforcement of arbitral awards. And that's not something that can be matched for settlement agreements. You mentioned the Singapore Convention or court decisions. The New York Convention of 1958, the Washington Convention of 1965 are instruments that grandly facilitate the enforcement of arbitral awards. So at least when you go to arbitration, you're likely to be able to recover assets that were lost. And that's, of course, a major advantage. Yeah. Maksud has a question.
I think Lawrence also has made a comment.
I'm very sorry if I miss someone. Let's take questions in order. Yeah. Uma, please do it. I will just let you run it as you were supposed to. My apologies for this.
No, that's okay. Lawrence has posted a comment saying that the significant rise in international arbitration may be attributed to globalization. Over the past decades, international standards have also started to be put in place, making countries, especially from the global south, to have become consistent and participating in arbitration in favor of the globalized community. That's his statement.
So it is more a statement than a question, but I fully agree with the statement. I mean, in the book that I mentioned earlier that I co-wrote with Alex Stonesweet, who is a professor in Hong Kong now, we describe how arbitration became globalized and how basically it has been imposing itself organically. So that goes, I think that participates to the statement you were making about the fact that it's strongly associated with globalization. It is a child of globalization, but also a factor of increased globalization. I could talk for hours about this, but I won't. I won't take more.
Okay, there are a few questions. Felicissimo has said, regarding the two cases given, what could have been the causes why the decisions of arbitration is lack of jurisdiction? You mentioned those two cases.
what
you mentioned those 2 cases in Philippines, which were dismissed because of lack of jurisdiction. He says, what are the causes for the decisions?
Oh, yes. So the ICSID jurisdiction, and I don't want to lecture you on ICSID jurisdiction, but in a nutshell, it's conditioned by a few elements that have to be fulfilled. And in that case, so there are the elements arising from the Washington Convention of 1965 that I was mentioning, Article 25, if you're interested. And then there are elements that are drawn from the bilateral investment treaty that apply to the case. In that case, if I remember correctly, but I would need to check, it was the BIT, Bilateral Investment Treaty between Germany and the Philippines, which contained its own conditions. 2 arbitral tribunals decided that these conditions were not fulfilled in that case. But in the meanwhile, of course, the Philippines had to defend itself for 11 years. Yeah.
The next question is, Christian, would appreciate your thoughts on institutions or even governments not wanting to comply with arbitral awards. Are there ways to make them comply? Okay.
Which institutions of governance of?
Government institutions or even governments not wanting to comply with arbitral awards.
Yeah. So that's a complex topic. It's difficult to give a blanket answer, of course. My view as a lawyer and as a professor of law is that when you get condemned, you should pay, the damages. I mean, that's basically fair game. There are instruments that I mentioned that facilitate the enforcement of arbitral awards, but there are still some exceptions. And sometimes the exceptions are fulfilled. And so it's very hard to give a blanket answer. A state may have good legal reasons to refuse the enforcement of an arbitral award if, for instance, this arbitral award has been annulled at the place of arbitration. That's one of the reasons provided for under the New York Convention, or if due process has not been respected. So there is a whole range of reasons that can justify non-payment of an arbitral award. That can get very technical, but I'm happy to follow up and, to give you a more. I
think a lot of hands are being raised, but another question here was, what is the likelihood of use of mediation after the advent of Singapore Convention in resolution of commercial disputes?
That's an excellent question. So I will narrow down the question. In the case of commercial disputes, it's rather likely. I mean, parties like mediation because for many reasons. In major industrial projects, it is less likely. And I'll explain to you why, and I'll give you one example. The reason is, as I explained earlier, and we determined together, major industrial projects involve very large companies and very often involve public entities. These are actors that are, and I'm saying that based on my own experience and also based on some research that has been done on this subject. These actors are less likely to agree to a mediation or to settle their disputes once these disputes have reached a certain level. And the reason for that is because these are very complex organizations and it's very difficult to make everyone agree on a solution. I'll give you 2 examples. Once I was involved a long time ago in a negotiation on behalf of a Southeast Asian state, actually. With my colleagues, we flew to that place to meet a major company, a big multinational company, to negotiate, find a solution to the dispute. It was not a mediation, it was a negotiation. So we flew maybe 12 hours or something like that. Everyone flew to this place. I won't disclose the name. And we sat for 10 minutes. It just didn't work. Another example is the ICSID conciliation system. So there is an arbitration system at ICSID. There is also a conciliation system. The ICSID arbitration system has attracted hundreds and hundreds of cases, highly successful. The conciliation system of ICSID, however, has attracted very, very few cases. The conciliation system of ICSID is very close to mediation. I think the reason is the one I gave you earlier. Complex, big corporations and states are sometimes unwilling to negotiate or find a settlement agreement. They need someone to decide for them for internal reasons.
Okay, there's another. In case of project dispute, who will prevail, either international arbitration or a national law of land? I think domestic law he means.
So I believe, but I might be incorrect, that the question is about whether local laws or international law are more likely to prevail over each other. So that's a very interesting question, because that's one I've written on. And in fact, a long time ago, the first half of my PhD was on this topic. And 20 years later, I still do not have an answer. In practice, these major industrial projects are grounded in a local system, in a national legal system. And an interesting feature of these major industrial projects, if you want more details, is that I've seen that several times. Major concession agreements are often incorporated into the legal system of the host state. They are made a national law. So that's a really, really strong indication that the parties want it to be national law. But we have seen a tendency in the past 20, 30 years to internationalize these contractual relationships and to make international law prevail over the national law involved in these disputes. I believe that we should not forget national law so easily. There is a major problem in international arbitration, and I rest my case on this, of ignoring or at least misapplying national laws for lack of knowledge or for unwillingness to engage seriously with a national law that may apply according to the concession agreement. So you're opening Pandora's box here. So I will stop here, but this is a major topic of international arbitration, and one that I believe is usually ignored by practitioners. I don't hesitate to say that, yes.
So thank you, Florian. I think there are some questions that people would like to raise, but we don't have time. So maybe we can pass it on to you, or they could email it to you and we can get the answers later.
Of course.
So I think on the whole, we've had a very good discussion, and especially the way you worded it as unwanted child. You know, the major industrial projects. That's really out of the box, and really something which projects and makes you think about where we are going. But of course, as you said, there is a future, and we have to plan for the future. So thank you so much. Over to Veronica.
Thank you. Thank you very much for a very interesting discussion. So we will come to the closing remarks of our session. So I invite Dr. Sitaram to give the closing remarks.
Thank you very much. Normally, we will close such session with a formal closing remark, but let me indulge in doing it very casually and informally. I actually want to thank Veronica first, because Florian is her teacher. And that's how I actually spotted on Florian, and we all benefited, and we wanted to thank Veronica for securing Florian's valuable time. And I want next thank the participants who asked so many questions. So this is like a great achievement for Madam Uma and Shreyas. Although we had the 2 hours and 3 hours of intense lectures today, Florian's lecture not only kept them alive, but they made so many questions that Florian couldn't finish answering all of them in the 1 hour we allocated. So Florian, we would like to have you back to engage with our participants. Now let me move into the formal part of why we had this session and what we learned from this. The whole motivation for this is very nicely, as Florian brought about, there are many public investments that are still needed and are waiting for cash from anywhere in the world. Money is available, but the systems are not available where money can come to the countries where they need the investments, and these long-term projects across political terms, across terms of government, can deliver results without conflict, or if there are conflicts, can overcome them. Many projects struggle, and unfortunately we have more bad examples than good examples of real cooperation and win-win for all. And as Florian mentioned beautifully, the arbitration is seen as a mechanism to help the process. The question that we couldn't discuss today, but I hope our participants will think about, is that what is the cost to government of not having a legal provision where their own domestic systems can handle these, right? They could not implement. Today, I don't have the answer to it, but we have excellent lectures and experts who are in the legal profession in the various countries, and students who will be the future legal experts. An analogy that I can give is easier for me from the medical profession. Legal profession, medical profession, all these are driven by national interests and national priorities. During this pandemic, we learned how countries are so vulnerable in the absence of a resilient and responsive medical system, which means doctors, nurses, and also healthcare systems which can take care of the citizens. In countries that have done well, it's interesting that it was the informal social mechanisms which actually continue to protect them. The countries that have had and continue to have universal health coverage didn't do any better, where systems were in place, but when a major pandemic we are still not out of the pandemic, we are learning these lessons, right? And then we find out that the existence of informal systems is not only important, it is also extremely valuable for hand-holding the formal system. I hope that analogy applies partly, if not fully. I'm not arguing a case, but certainly for the legal provisions for bringing investments in infrastructure projects in developing countries, which is what I have been working on for several years. And I've found that every time we fail, it's due to lack of legal provisions to enforce contracts, to honor the original agreements, and so on. But as we have learned from Florian's lecture today, many of these contracts are not actually, if you put the honor quote, quite fair, and they are maybe skewed, that in the case of any problem, the winner is always the one who wrote the contract first, and as Madam Chitra made, it maybe comes from the north, so the loser is always the government who didn't know at the beginning what they were playing into if things don't go well. This is what I hope we can share with the young generation here to get smart. How can we be having a fair play as we move forward? Because we also want development, we also want to put cash where it can provide development and open markets. When we say open markets, it's about head count and people being able to afford and enjoy all the services as human beings that we all actually deserve. I don't know if this is serving well or provoked you more to have further conversation, but we have come to the end of the allocated time. Thank you all very much for participating, and wherever you are, good afternoon or good evening and good night.